Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12CR1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Let's bring the jury in, please.
Your Honor, could I ask one quick thing? In an upcoming witness very soon, we were going to address the issue of those Gmail chats, and I know the court had wanted to have an opportunity to look at them and rule on them. I just wanted to bring that to the court's attention.
Yes, could you get that for me, please? It's on my round table. Thank you. Thank you. I did have a chance to review People's Exhibit P-TR-649 last night and today, and mostly this morning. And for the same reasons that I ruled that Exhibit P-TR-1227 is admissible, I find that this exhibit is also admissible. So I incorporate by reference the lengthy comments I made yesterday with respect to Exhibit P-TR-1227. There were 3 objections made with respect to Exhibit P-TR-649 by the defense. One of them was under Rule 802 of the Colorado Rules of Evidence. That's the hearsay rule. To the extent that the Gmail chat between the defendant and his former girlfriend, I believe her name is Gargi Datta, his statements are not hearsay because they are admissions by a party opponent. To the extent that they contain Ms. Datta's statements, those statements are not hearsay because they're not being introduced for the truth of the matter, but rather to place the defendant's statements in context so that the jury can understand what it is that he was saying in the Gmail chat. In terms of the objection with respect to relevance and also the objection with respect to Rule 403, as to relevance, I find that these Gmail chats are probative for all the reasons that I stated in my lengthy ruling yesterday on Exhibit P-TR-1227. But I think in a way, this is even more probative than those emails because this exhibit depicts, in a lot of ways, the defendant's relationship with his former girlfriend. This was the first and only romantic relationship that he had before the shooting. And the experts who have testified so far, both of them, Drs. Reed and Metzner, have talked about this relationship, have relied to some extent on this relationship. There has been a lot of talk by the parties in the trial, including in opening statements and in the questions asked of witnesses, that have referred to the defendant's ability to form relationships and the defendant's ability to socialize. This has been a big theme throughout this trial. There seems to be a disagreement, as I said yesterday, between the defendant's shyness and the defendant's nature as an introvert were just personality traits, normal personality traits that you see in people sometimes, or whether they were indicative of some kind of mental illness. These Gmail chats also contain discussions about friends that the defendant has, so it's not just about his relationship with Gargi Datta, but also with respect to other friends. It also talks and shows information related to activities that the defendant was engaged in, things he was doing with friends, things he was doing with Gargi. It also contains information related to his views on school, and specifically some of the labs there are a couple of Gmail chats that refer to or that appear to imply that he seems bored or unhappy with the work in the lab and that he wishes he was doing different kind of work. I think at some point he refers to neuroscience and how he would be more interested. He's more interested in neuroscience, but that's a soft science. And that goes to, again, some of the themes that have been developed throughout the trial as to whether he was lacking in motivation for whatever reason at school, or whether the lack of motivation was an indication of mental illness. So that is also, the exhibit is also probative for that reason. There's some discussion as well about what's referred to as the rapist, and it appears that it may be a reference to therapy, a therapist, and I don't know if that's a take off of the SNL skit. Instead of referring to a therapist, it's the rapist. I think in one particular Gmail chat, the defendant refers to the rapist, and he's asking Gargi if she's going to go see the rapist, and then he adds something like, for $400, Alex, referring apparently to Alex Trebek. And that's the skit from Saturday Night Live where they're playing Jeopardy, and instead of saying therapist, the person says the rapist. And it appears that Gargi is going to therapy. The defendant talks about how he had therapy when he was young, but it was group therapy with his family and he didn't enjoy it. So it's relevant for that reason too. There are statements in here, I think, that that are probative of the defendant's views to some extent about therapy and therapists. Those are the notes I wrote. So for all those reasons, it is clearly relevant under Rule 401. The question then is it admissible under Rule 403? And I haven't heard anything that leads me to believe that this would be, that there is a risk of undue prejudice, or that any of the concerns listed in Rule 403 would require the exclusion of the exhibit. In my view, the probative value of the exhibit is not substantially outweighed by the dangers of unfair prejudice. And I want to make clear that Ms. Brady, I think, told the court yesterday she has no objection to the last Gmail chat, the one from March 25th of 2012. And it's a lengthy Gmail chat, but and it's one that Dr. Metzner specifically relied on informing his opinions. But in my view, if I'm going to admit that Gmail chat, I think, again, it is important to admit some of the earlier Gmail chats. It goes to what I said yesterday. You can't just show the picture between March and July and expect the jury to assess and evaluate all of the arguments and all of the issues that are being made in this trial. You have to have some point of reference for the jury. You have to provide the jury a point of reference, something to which it can compare the defendant as he was in 2012, and specifically between March and July of 2012. If the jury's just shown that snapshot, the jury can't assess the arguments that I have discussed that have been developed throughout this trial, and the contentions that are being made and the issues that are being put before the jury. So I think in terms of the time frame, it is relevant. I think the earliest Gmail chat goes to October 10th. It's certainly within the time frame that the experts have talked about. Both experts have said that the defendant had negative symptoms or some type of symptoms of mental illness even before then, and so this is within the relevant time frame. It is certainly within the school life of the defendant, and so it's also within that time frame as well, which I have discussed at length before. So for all those reasons, I find that the probative value is not substantially outweighed by any of the dangers listed in Rule 403. So it is admissible. All right, Mr. Brockler, you may approach and you may retrieve the exhibit. And with that, are you ready for the jury?
Yes, sir.
All right. Are you ready for the jury, Ms. Spengler?
We are, Your Honor. I do notice that the model is out, and this might be a good time or perhaps closer to the lunch break for the court to read the instruction regarding the model.
Yes, thank you for reminding me. Let me try to find it. I will give it at the next time that it's used, okay? All right, let's bring the jury in, please. And before I do that, actually, I think the prosecution was going to review the instruction. Let me just make sure the record is complete on this. What happened is the defendant tendered an instruction, and it's been marked as defense tendered instruction number 1. I made some revisions to it, and I gave the defense a couple of choices, and one of them was just to have the first paragraph of this instruction as I have revised it. The other one was to have both paragraphs of this instruction, which I which basically is the two paragraphs in my instruction follow the two paragraphs in the tendered instruction, but I have revised both paragraphs. As I understood it, without waiving her objection, Ms. Spengler chose the instruction that has both paragraphs with my revisions as opposed to just having the first paragraph. And do the people have anything to add to this or anything to say, any objection that you want to make, any additional objection? I overruled your request to introduce the exhibit as substantive evidence, but is there any objection to the instruction as I have revised it?
No, Your Honor.
Okay, thank you. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Welcome back, members of the jury. Call your next witness, please.
Patricia Legreta Roars.
Good morning. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm under penalty of blood that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Please tell us your full name and spell your first, middle, and last names.
My full name is Patricia Legreta Roars, Patricia Legarreta Rohrs.
All right, Ms. Tish-McGuire, you may proceed.
Thank you. And I'm going to first ask you to pull that microphone really close to you. Thank you. Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes.
Did that go into the early morning hours of July 20th of 2012?
Yes.
Please tell the jury a little bit about what you remember from the day of July 19th prior to going to the movie theater that day.
I was grocery shopping. My boyfriend at the time was sick. I was running around doing all the errands. I had gone to Sam's Club, Walmart.
What time did you decide to get the movie tickets that day?
I had finished around 4 or 5, and the Walmart is close to where the theater is at, so I called my boyfriend to see one last time if he wanted to go to the midnight premiere of Batman, and when I called, he had, was like, yes, let's go. So before I went home, I stopped and got tickets for all of us and then went home.
Could you please tell the jury who all of us is?
All of us is my boyfriend at the time, who's now my husband, Jamie Roars, my daughter, Azariah Roars, and our son, Ethan Roars.
Now, how old was Ethan Roars at the time?
He was 4 months.
4 months old.
Yes.
And how old was Azariah?
She was 4 years old.
What time did you arrive at the movie theater that night?
I don't know the exact time, but it was after 11.
What did you do when you got to the movie theater?
We found seats, and then my daughter needed to use the bathroom, so me and her went to use the bathroom, and then we went back into the theater, sat down, and I remember I hardly ever pay attention, but they were showing, it wasn't previews, but like commercials, and me and my daughter were freaking out and laughing because it was the first time that we'd ever been in a theater that had a back exit. And so me and her were like, oh, how cool, turned around, noticed the exit, and then that was it before.
What brought your attention to the fact that there was a back exit?
Like I said, the fact that I'd never been in a theater that had one. Usually it's just front exit. So me and my daughter thought that that was cool that we were, first time being in a theater with back exits.
Was there a commercial that drew your attention to that back exit?
Yeah.
Judge, I'm going to object at this point to cumulative.
Overruled.
You can go ahead and tell the jury.
I remember the whole cell phone thing and dancing cell phone, and then just the fact that it was like showing know your exits, and talked about the ones at the front, and then when it said the back, I was like, oh, that's different.
Was there anything about the previews for movies that you remember?
I don't remember all of them. I do specifically remember the Superman preview because I remember a male shouting like yay or woohoo, and a cheer of excitement, and everybody kind of like laughing like.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1159.
Yes.
Do you recognize that diagram?
Yes.
Does that diagram fairly and accurately represent what you remember happening on July 20th of 2012 in the theater?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibit 1159.
Is there any objection?
No objection.
Without objection, it is admitted.
Your Honor, at this time with the court's permission, I would ask Ms. Legareta Roars to join me at the 3D model to describe for the jury what she remembers happening in the theater that night.
Okay. And members of the jury, this is a good time for me to give you an instruction. It's as follows. This is an instruction with respect to People's Exhibit P-TR-1087, which is the physical model of the inside of Theater 9, a portion of the inside of Theater 8, and the area outside of Theater 9. I'm referring to the model that's there in front of you. A mark on this exhibit was corrected following the testimony of Brett Mills. Mr. Mills testified that the single impact in row 1 at seat 16 identified in earlier testimony by crime scene investigator Maria Perolina was actually a fabric tear and not related to a bullet or bullet fragment. Therefore, the circle drawn by investigator Perolina on seat 16 in row 1 has been removed from the exhibit. Exhibit P-TR-1087 is a demonstrative exhibit and has been allowed by the court only for use in the courtroom to help you visualize certain physical spaces at the Century 16 theaters and to allow witnesses to explain and illustrate their testimony. Therefore, this exhibit is distinguishable from items that have been admitted as substantive evidence, which you may have an opportunity to view during your deliberations. Does everybody understand that? And people are nodding their head yes and saying yes. All right, with that instruction in mind, ma'am, you may step down and bring the handheld microphone if you would, please. Yes, thank you.
If you just turn that on, please, and I'll have you kind of stand right back here with me so the jury can still see everything. All right, if you could please, first of all, show the jury where you were seated that night.
We were seated about row 14, 15, around this area.
All right, so if you could just make your best educated guess and then tell them where exactly, what seat you were in.
She can't guess. She can estimate.
I apologize, Your Honor. If you could just show the jury approximately where you believe that you were seated that night.
This row.
Okay.
And
If you could tell him what seat you were in.
I was in this seat.
Okay. And what seat was your boyfriend at the time, Mr. Roarson?
He was in this seat, and Azariah was sitting in between us.
Right. And where was your son Ethan?
Ethan was asleep, and he was in my boyfriend at the time's lap.
Now, what do you recall happening in the movie theater that night?
I remember watching the movie and at some point seeing the exit door on the right side opening and seeing something come flying across and around right here in this area. You heard a pop and then smoke, and I remember thinking like a prank, or sometimes you hear about different midnight premieres, doing different things, and so we continued watching, and then you see the exit door open again, and you could see it because it was so dark, but you could see the light, and I just remember hearing popping sounds, and my boyfriend yelling to get down. And my daughter was asleep, so I remember grabbing her and just throwing her to the ground and laying on top of her.
Now, could you show for the jury on the diagram where it was that you would have been putting Azariah on the ground and laying on top of her?
Right here.
And then what do you recall while you were on the ground with Azariah?
I just recall trying not to panic and thinking to myself to just thinking this isn't happening. And then I remember looking up and seeing my husband cradling Ethan and jumping over the seats to get safety because he was struggling to find room.
Objection as to speculation.
Sustained.
All right, so you saw him physically jump over seats.
Yes.
Okay, and what did you see him do?
After seeing him come over, I didn't see anything else, like where he went.
Okay, so you lost sight of Ethan
Yes.
and Mr. Roars at that point.
Yes.
So what happened with you and Azariah at that point?
We stayed down, and I just remember poking my head up to kind of see what was going on, to figure out what our next step was going to be. And I remember putting my head up and seeing flashes, and I put my head immediately back down, and as soon as I put it down, I remember feeling a pain in my right leg, and I remember screaming and saying, I think I got shot. And then I remember a voice behind me saying...
Objection as to hearsay.
It's being offered for the truth.
No, Your Honor.
What's it being offered?
It's offered for the effect on the listener.
All right, the objection's overruled.
Right, you can go ahead and tell the jury.
I remember hearing a voice say that I did too, and I remember feeling just a little bit of comfort knowing that I wasn't alone. And it was at that point where I realized that any movement that I made, if I was visible, it was probably going to be shot in that direction. So I tried to stay low, but I was still in my head trying to think, I need to get out of here. I can't stay in here. And at that point, I heard crying, and I looked up in the aisle and found Ethan. And I remember grabbing him, and that's when I knew that I had to get out. So I just started listening, and I noticed that the shots weren't coming as quickly, and that was when I took my opportunity to get up, and I pulled my daughter up and I dragged her up the stairs, and I remembered there was that exit, and I knew I just had to get out those doors. And I remember going through the doors, and I was literally dragging Azariah behind me and holding Ethan and just trying my hardest to just get out.
So now when you found Ethan, was Ethan by himself?
Yes, he was.
Okay. And when you said earlier you had stood up and you saw some flashes, could you tell the direction of those flashes?
I could see that they were on that side of the theater.
Now when you were hearing the gunshots in the theater, could you hear any different types of gunshots?
Yes, I noticed
I'm going
that...
to object now to foundation.
Overruled?
You can go ahead and tell the jury.
I remember that there were differences, like rapid shots, and then there were some that were a little deeper, but not as rapid.
And when you said that you heard the voice of someone also behind you who had said that he got hit also, where was that? Was that person in the same aisle as you?
Yes, it was in the same aisle.
So when you said behind you,
It was, yeah, we were right here, so somewhere, yeah, in that seat right there.
now did you have an opportunity after the shooting to meet that individual?
Yes, I did.
Judge, I'm going to object at this point. It's no longer not being offered for the truth of the matter asserted.
I don't think the question called for hearsay, so the objection's overruled. I don't think it was a question about what was said.
Thank
So
you.
overruled.
Thank you, Your Honor. So did you have an opportunity to meet that individual after the shooting?
Yes, I did.
And do you know who that person is?
Yes, I do.
And what is that person's name?
Jarrell Brooks.
Okay. So how did you go about, just if you could show on the diagram how it was that you went out about getting out of the theater?
I grabbed the kids and ran up this way, and I remember having to go through one door, and it was a little room, and then going out another into like a staircase that went out into the lobby.
All right. And earlier, I think I'd asked you if you had an opportunity to hear different types of gunshots, and what were the differences that you remember hearing?
Some of the shots were more rapid, constant, boom, and then the other set was not as rapid, but like a deeper sounding.
Thank you very much. You can go ahead and take your seat back at the witness stand. Now, what happened when you...
Hold on, Mr. McGuire, before you proceed. The last objection as to hearsay is actually now sustained based on what you said. This went to identification, but there was not enough foundation, so that is hearsay. So the statement by this witness as to who the person was behind her, that is stricken, and the jury will disregard it and treat it as though it never heard it. All right, you may proceed.
After you got through the door, the theater, what did you do next with Azariah and Ethan?
I remember walking around the parking lot, hoping to find Jamie, because at that point I had no idea what happened to him. I left my purse and cell phone in the theater, so thankfully someone let me their phone, and I called him.
And I'm going to object to relevance as to what happened outside of the theater.
What's the relevance?
There's how she goes about getting medical treatment.
Okay, the objection is overruled.
So someone let me their cell phone, and I was able to get a hold of Jamie. We found him right away, and he could see that I was bleeding from my leg. So he, instead of waiting, because at the time it was still chaos, so we jumped in his truck, and he drove me straight to the hospital.
What hospital did you go to?
Is it the Colorado University? I can't remember the exact name.
University.
Yeah, University Hospital.
What injuries had you sustained at the theater?
It was shrapnel.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 2548 and 2547.
Yes.
Do you recognize those photographs?
Yes.
Did you, do they fairly and accurately represent you at the theater on July 20th, you at the hospital on July 20th of 2012?
Yes.
Okay, and do they fairly and accurately represent the injuries that you sustained?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibits 2548 and 2547.
Any objection?
No objection.
Without objection, P-TR-2547 and 2548 are admitted and may be published.
Thanks. If I could please have 2548. All right, it's a picture of you at the hospital that night?
Yes.
Or early morning, rather. And if I could please have 2547. And that's the injuries you sustained to your leg?
Yes.
Did you also sustain some shrapnel injuries to any other part of your body?
Yes.
And could you tell the jury about that, please?
You can take that picture.
On my right leg as well, all the way up my thigh, and up to my hip.
You had shrapnel injuries all the
Yeah.
way up, and they just didn't take pictures of them?
No.
I have no further questions. Thank you, Your Honor.
Is there any cross-examination? Ms. Spengler?
No, there's not.
And the jury does not appear to have any questions. May this witness be released from her subpoena?
Please, Your Honor.
Is there any objection?
No objection.
All right, ma'am, thank you. Call your next witness, please.
Gordon Madonna.
Good morning, sir. You solemnly swear or affirm under penalty of blood that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, please be seated. Can you hand me those two exhibits there, please? Thank you. Melissa? You there. Thank you. Could you please state your full name for the record, and please tell us or spell your first, middle, and last names?
Do I have to give you my middle name?
You
Gordon.
can do an initial if you'd like.
Gordon G. Madonna, and that's Gordon Madonna.
And what's your middle initial?
G.
G? Okay. All right, you may proceed, Mr. Edson.
Thank you, Your Honor. What is your occupation, sir?
I'm a police officer, detective,
With what agency?
Aurora Police Department.
How long have you been a police officer with the Aurora Police Department?
With Aurora, 21 years.
Do you have any prior law enforcement experience?
Yes.
Tell us about that, please.
40 years law enforcement experience.
What type of assignments have you worked as a police officer for the city of Aurora?
I've worked from patrol to what they call the Police Area Representative Program, which is PAR. Worked for, in that assignment, business specialties. I've also worked through crime prevention, through environmental design with the planning department. I've taught DARE for quite a few years. I've been a detective for quite a few years, working various assignments from larceny to economic crimes, or fraud, crimes against children, and digital forensics.
Are you currently a detective?
Yes, I am.
What is your current assignment with the Aurora Police Department?
I'm on assignment to the Federal Bureau of Investigation. It's called the Regional, or the Rocky Mountain Regional Computer Forensics Lab, which is down at Dry Creek and I-25.
Is that also sometimes just referred to as RMR CFL?
Yes.
What do you do for RMR CFL?
I'm a forensic examiner.
What is a forensic examiner?
Forensic examiner, digital forensic examiner. We examine various digital devices such as computers, cell phones, in the past PDAs, digital cameras, things like that.
Could you tell us about your educational background, please?
I have an associate's degree of applied science in criminology from the Community College of Aurora. I've attended Metro State College, plus well over 1,000 hours in computer forensics training.
Are you in fact a computer forensic examiner?
Yes.
Tell us about any specialized training you've received in order to, in the field of digital and computer forensics and examinations.
I initially started in 2000 with my first examiner training. I've had various classes from the tools that we use, such as Access Data's Forensics Toolkit, guidance softwares, Encase, X-Ways Forensics, Max Forensics, Parabon, the list goes on.
In general, something like the forensic toolkit you talked about, what are we talking about? What are those things?
That is the software that we use to be able to analyze digital evidence.
Have you received training and background education in a variety of type of software for a variety of different types of electronic devices and computers.
Yes.
Is that ongoing training?
Yes, it is.
Talk to us about that, please.
Well, initially, you get your basic training and so forth, and then you have to take usually 2 classes a year minimum training. We normally do a lot more than that. And then every year you have to pass proficiency tests to show that you're capable of using the software.
Have you been doing that?
Yes.
What type of software are you getting this continuing accreditation?
And the different tools that we use, such as FTK by Access Data, Forensics Toolkit, that's acronym for it, NCASE, X-Ways, Internet Evidence Finder by Magnet Forensics, those type of tools.
I'm going to kind of break this down a little bit. Some of the devices that you perform examinations upon, forensics examinations, does that include computers?
Yes, it does.
Does that include laptop computers?
Yes, it does.
Some of the newer tablets, does it include that?
Yes.
Does it also include the variety of cellular phones that are available?
Yes.
Does it also include other electronic devices, music devices, Apple devices, Mac devices, things like that?
Apple devices, Mac devices, yes.
What about the various companies, Google, Microsoft, things of that nature?
That usually enters into, yes.
Okay. Are you a member of any professional organizations in relation to the area of computer forensics?
Yes, I am.
Tell us about that, please.
I'm a certified forensic examiner with the Federal Bureau of Investigation. I'm a member of IASIS, which is the International Association of Computer Specialists, member of HTCIA, High Tech Crime Information Association, Investigators Association, the HTCC, High Tech Computer Crime. And I may be missing some of the acronyms there a little bit. And I've also belonged to the Colorado Association of Computer Crime Investigators, past president, vice president, secretary, board member, so forth.
I may have missed this, but do you currently have a certification with the FBI related to computer forensics?
Yes, I do.
Did you have to go through any specialized training related to that?
Yes.
Tell us about that, please.
It's normally a 2-year program of intensive training classes that you have to attend, minimum criteria, and I began that certification process back in 2005 and was able to complete it in 9 months.
Does that also require ongoing training?
Yes, it does.
And have you been doing that?
Yes.
Are you familiar with the acronym CART, C-A-R-T, in relation to computer forensic analysis?
Yes.
What is that?
CART stands for Computer Analysis Response Team, which is actually the program or the bureau, or well, bureau level of the FBI that sponsors the digital forensics labs.
Are you a member of that in any sort of way?
As a task force officer, yes.
Okay. Have you received any sort of, are you required to go through that type of training to maintain certification?
That would be the same training, yes.
Okay. Have you successfully completed yearly proficiency testing?
Yes.
Have you done that every year since you've been certified?
Yes.
What exactly, if you would please, is the Rocky Mountain Regional Computer Forensics Lab that you work at?
The lab is one of 16 labs that's scattered across the United States. Our territory is Colorado and Wyoming, so any law enforcement agency within those jurisdictions can submit evidence to us. We also assist other labs throughout the United States when they get backed up or national emergency or whatever it happens to be, some big event, we'll assist those. We're deputized U.S. Marshals. We can travel anywhere in the United States.
Is that you are as well?
Yes.
Okay, continue.
This lab is consists of, I think it's, last I checked, 13 different agencies that are participating throughout the Denver metro area. And I think we had, last I checked, was 19 examiners or people assigned to that lab.
How long have you personally been a computer forensic examiner?
Since 2003, and with the Bureau since 2005.
In the same capacity?
Yes.
Even prior to your assignment with the Rocky Mountain Regional Computer Forensic Laboratory, had you received any previous digital or computer forensic training?
Yes.
Talk about that, please.
Started in 2000, year 2000, with NW3C basic data recovery, and completed quite a few classes up until then. And then 2003, we initiated the in-house computer forensics lab in Aurora. And from there, 2004, I went to what at that time was a regional computer forensics lab in Douglas County. I was there until we merged into the FBI lab in 2005, April.
And is that merger still in effect today?
Yes, it is.
Was that merger in effect back in 2012?
Yes.
Have you ever testified in court as a digital computer forensic and/or cell phone examiner?
Yes, I have.
In what types of courts have you previously been qualified as an expert?
Been qualified in the as an expert in the 18th Judicial District in Arapahoe County, Douglas County, the 2nd Judicial District, Denver, Aurora Municipal Court, 17th Judicial District, Adams County, and the 10th Circuit U.S. District Court, State of Wyoming.
If you had a rough estimate as to how many times you've testified as an computer forensic examiner for computers and/or cell phones in an expert capacity, what might that be?
I think it's about 7 times.
In your career as a computer forensic examiner, if you had to kind of ballpark for us how many examinations and pieces of evidence that you've conducted as an examiner, what would your answer be?
Last I checked, which has been a while ago, I've done over 600 examinations, over 78 terabytes of data.
What's a terabyte?
It's a very big, long figure. A terabyte, if you had to explain it, well, the Library of Congress, last figures I seen was about 28 and a half terabytes. So it's about 2.5 times the Library of Congress.
Okay. Are you familiar with the term peer review in your field?
Yes, I am.
Do you engage in peer review frequently when you're examining items of evidence?
Yes, we
Objection,
do.
Your Honor, to relevance, bolstering.
Overruled.
Go ahead.
Yes, we do.
What exactly is peer review?
Peer review is any examinations that we do in the FBI lab. We require 100% peer review. So you do your examination, you create your notes, write your notes, and so forth, and another examiner has to look at that, follow your notes, read them over, and they have to be able to theoretically complete or do the exact same examination that you performed and come up with the same results.
Is the Rocky Mountain Regional Computer Forensic Lab an accredited lab in any sort of way?
Yes, we are.
Explain, please.
We're accredited through the ASCLD, which is the American Society of Crime Lab Directors, and we're accredited internationally. I believe we completed our first certificate or accreditation in 2008, and then just recently 2013.
Forgive me if I've already asked this, but going back to your being an expert and previously testifying in other courts, has that also been for cell phone analysis?
Yes.
At this time, I would move for admission of Detective Gordon Madonna as an expert in the area of, in the field of forensic examination of computers and electronics to include computers and cell phones. Under 702, People v. Schreck, and the court's previous rulings in this case.
Any objection, Ms. Spengler?
No objection.
All right, without objection and based on my previous ruling in Order D-108 and pursuant to Colorado Rule of Evidence 702 and the decision in People v. Schreck, which is published at 22 Pacific 3rd, 68, 2001, the court will accept, is it investigator or agent or?
Detective.
Detective Madonna as an expert witness in the field of forensic examination of computers and electronics to include cell phones. What that means, members of the jury, is that I have accepted him as an expert witness in that field, and now he is permitted to render expert opinions in that field because he has been qualified to do so. I remind you that you're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. With that, Mr. Edson, you may proceed.
Thank you, Your Honor. I think nowadays most everyone knows what a computer is, but tell us what forensic examinations of computers, what does that entail?
The process entails the department, police department, or whether it be the Aurora Police Department or any other law enforcement agency, submitting a request for service for our services, along with a copy of the search warrant authorizing them to do so in an affidavit. That, whether it be in the FBI lab or the Aurora lab, is basically the same process. That has to be reviewed, and if the examiner and the intake people concur that the agency has a jurisdiction through the warrant and so forth, then we'll accept the evidence, make reservations for them to drop off the evidence, whether it be computers, cell phones, things like that. And then that evidence is entered into a controlled system, evidence control unit, where it's barcoded, labeled, tracked through the entire process. And then the digital evidence is then what we call imaged. In other words, we make a copy of that digital evidence, and then we work from the copy and protect the original evidence. That is processed through our forensic software, and then the examiner will look through, with using that forensic software at the information that's on those devices at the request of the law enforcement agency. Some may be looking for specific things, whether it's pictures or it's what we call, also refer to sometimes as images or documents, those type of things.
Okay. Are there a specific, well, let me retract that statement. I get the sense there's a couple of different labs. You talked about an Aurora lab, and then you said the Rocky Mountain lab. Are there two different labs?
Yes, there is.
Talk to the jury about that, please.
Okay. I'm assigned to the Rocky Mountain Regional Computer Forensics Lab. The Aurora Police Department has a computer forensics lab also that's in-house. One examiner is assigned to that lab.
Who is that examiner?
That's Mike Leiker, Detective Mike Leiker.
Okay. So just so we're all on the same page, you are a detective with the Aurora Police Department, correct?
Correct.
Do you work in the Aurora lab?
Occasionally, when they need assistance, yes.
Okay. But you also work in the Rocky Mountain lab as you previously
That is
said?
my full-time position, yes.
Right. You use the term making a copy or an image of the computer hard drive, I believe.
Yes.
Talk to us about that. How does that work?
Well, most everybody here has had computers. You know what a hard drive is. The hard drive is a piece of equipment inside that computer where all the information is stored. That when that computer comes into our facility, whether it be Aurora or be the Rocky Mountain Lab, that hard drive is removed from the computer and is placed behind what we call a write blocker. That write blocker can be a physical write blocker, which is actually a piece of equipment, or it can be a software write blocker, which is actually operated through software. And the idea is to preserve the original evidence so that you do not alter or change anything on that original evidence. And what we do is we acquire that to our servers. And at the very beginning, we use what's called a hash, or in this particular case, a MD5, which stands for Meta Digest 5, which is an algorithm that we can apply against that hard drive, and it gives us a digital fingerprint of what the information is on that hard drive. When we're done with our imaging, then we'll run that hash against the image, and we should get the same digital fingerprint. If we get a different fingerprint, we know that something's changed. Okay, and then we go back to square one and figure out what's going on. Sometimes hard drives start having problems. What we call flipping a bit. If a 0 changes to 1 or something like that, it's going to throw that entire MD5 hash off, and we'll know that something's wrong. So that's how we check and verify that we have the exact information that's on that hard drive. Once that occurs, then the hard drive goes back into the original computer. It stays in property until it's released back to the original agency or back to the property unit in Aurora.
Why do you not work on the original hard drive?
It's just like any other scientific analysis. You want to preserve the original evidence. So another examiner can come in and do the same imaging and come up with the same results.
What do you do with the original hard drive or the original actual computer once you're done making the copies you described?
Once we're done with it, it goes back into our evidence, and it stays there until the report is released to the agency, and it's transferred back to their evidence control custody.
Is there any difference between when you look at the hard drive of a computer, say a tower computer, like you can buy anywhere, versus a cell phone?
Yes.
Tell us about that, please.
Well, with hard drives and so forth, they're a little bit easier. Cell phones, the minute you turn on a cell phone, it's automatically changing its memory. Okay, so a hard drive is magnetic. It's either there in what we call bits and bytes, or with a cell phone, that's different. A cell phone, it has to be designed in such a way so that it's constantly changing its memory. It's reorganizing that so that it's more efficient, whereas you don't see that on computers unless specifically told to do so, commanded to do so.
When you're conducting a forensic examination of a piece of electronics like a computer, what information or evidence are you specifically looking for?
It depends on whoever, what we refer to as the case agent, the detective that submitted the request, what they're looking for. If they're looking for, if it's child pornography, images, those type of things. If it's a white-collar crime, such as your documents, spreadsheets, and so forth.
Now, you're a detective with the Aurora Police Department, correct?
Yes.
Describe how your role, even though you're a detective, when you're conducting a computer forensic examination for a case agent like you just described, or in this case, someone like Detective Apple, what is your role versus the other detective within the Aurora Police Department?
Well, we're not we don't act like investigators, okay? We only specifically look for what we're asked to look for and that type of thing. We're totally removed from the investigation. A lot of times we don't know anything about the investigation itself other than what we're told. The specifics of how that computer, that equipment got there. I guess the Bureau refers to it as dispassionate scientists. So we don't have anybody overlooking us saying, you know, you have to find this or you have to do that. It's completely independent.
Okay. Are you familiar with a tool called Cellbrite?
Yes.
What is that?
Cellbrite is a tool, a software tool that's designed to acquire information from cell phones.
The forensic toolkit, the FTK, can that be used on cell phones?
Yes, it can.
What else can it be used on?
Computers, hard drives.
Is that a common software that you use in analysis?
Yes.
When you are conducting an examination of the copy as you described, do you ever create any sort of images or documentation as to what you're finding?
Yes.
Describe that, please.
Ultimately, when the examination is completed, if there are findings, we will complete what's called a findings disc or DVD or Blu-ray, depending on what it is, and that will contain the items that we found that were pertinent to the case.
And those items, are those the ones based on what the case agent had requested of you?
Yes.
I'm going to direct your attention to July of 2012, specifically July 21st of 2012. Were you then a detective with the Aurora Police Department?
Yes.
Were you at that time assigned to the Rocky Mountain Computer Forensic Laboratory?
Yes.
On July 21st, 2012, did you become involved in any sort of way related to the theater shooting case at the Century 16 Theater?
Yes.
I'm going to backtrack to July 20th. We all know the dates of when this happened. Did you have any involvement on July 20th from a detective perspective?
No.
What was the first aspect of your role in this case, going back to July 21st, 2012?
On the 21st, about 9 a.m., I received a phone call from Detective Mike Leiker, Aurora Police Department, requesting assistance.
You described him already, but who is Detective Liker?
Detective Liker is the computer forensic examiner for the in-house lab at Aurora.
Do you oftentimes work with Detective Liker?
Yes.
Was there a particular piece of electronics that you were requested to assist in the examination with back on July 21st, 2012 at that time?
Yes.
What was that?
An iPhone?
Your Honor, may I approach to retrieve an item of evidence, please?
Yes.
Thank you. Sir, I placed before you what's been previously admitted as People's Exhibit 538. Do you recognize that?
Yes, I do.
What is that?
iPhone?
Is that the iPhone that you were requested to conduct an examination upon?
Yes.
Where was the iPhone when you first received it?
It was already at the Aurora Police Department computer forensics lab.
Did you begin work on the examination of the iPhone at that time?
Yes.
Was that a computer forensics examination?
Cell phone or digital cell phone examination.
At some point, again on July 21st, 2012, were you requested, was your presence requested related to other electronic items?
Yes.
Talk to the jury about that, please.
I was requested to respond to, and I have to look at the exact address, I think it's 1690 Paris Street, to meet with the ERT team, which is the evidence response team from the Federal Bureau of Investigation, to collect digital evidence.
Are you familiar with the Federal Bureau of Investigation's evidence response team?
Yes.
Had you worked with them prior to July 21st, 2012?
Yes, quite a few times.
Are you familiar with an individual by the name of Dan Lehman?
Yes, I am.
Who is that?
He is the supervisor for the ERT team, special agent.
Are you familiar with the, well, let me ask it this way. Did you respond to the 1690 Paris Street address in Aurora?
Yes, I did.
Are you familiar with that area of Aurora?
Yes, I am.
What county is that in?
Adams County?
Are you also familiar with the Century 16 Theater?
Yes, I am.
What county is that in?
That's Arapahoe County.
Did you ever go to the theater for any reason on July 21st, 2012?
No.
What did you do when you arrived to the Paris Street address?
Talked to the detectives that were there. I believe it was Detective Wilson, the supervisor Pat Smith, and Special Agent Dan Lehman. They advised me of the status of what they were doing and so forth, and that they weren't ready for me yet, so I kind of waited around for them until they asked me to respond inside to collect the evidence.
Would that be Detective Tom Wilson?
Yes.
Were there items of evidence you ultimately received or took into custody?
Yes.
What were those items of evidence?
The tower computer, NZXT, I believe, a Lenovo tower, Toshiba laptop, a Lapan tablet. There was a modem and a wireless device, and I think there was about 7 items.
Where were those items when you took them into your possession?
They were in the hallway next to on the 3rd floor next to the apartment.
Okay. Were they right outside of the apartment?
Yes.
When you arrived on scene, was there law enforcement keeping watch over those items when you arrived?
Oh, yes. Special agent from the Bureau, Jeff Holmes, was there.
Okay. Are you familiar with Jeff Holmes?
Yes, I am.
Did you take into custody those items from Jeff Holmes?
Yes.
What did you do with the items?
Myself, Detective Wilson, Tom Wilson, and the CSI, Darvin Harrell, brought those items down to the CSI van and placed them in the back there, closed it up, and CSI Harold drove him to the Aurora Police Department, and I followed him immediately behind him. And once at the Aurora Police Department, we unloaded the van, brought him directly up to the computer forensics lab.
Did you maintain eye contact with CSI Tech Harold the entire trip?
Yes.
What time was this at?
I'd have to look at my notes to be sure. I think I went upstairs about 7:30, and it was about 8:30 when I finally received the evidence.
In the evening?
Yes.
And this is again July 21st?
Yes.
What happened to the items once you took them to the laboratory?
They're brought into the lab. They have to be inventoried. They have to be photographed. They were processed for fingerprints and DNA evidence.
And did all of that occur in this case?
Yes.
At some point later in July 21st, later in the evening of July 21st, 2012, did you receive some additional electronic type items from the apartment?
Yes.
Talk about that, please.
Special Agent Holmes responded to the Aurora Police Department, and he had 2 thumb drives in his possession, and advised that they came from the apartment and he needed to add them to the evidence to be processed.
How many total thumb drives were examined?
I would have to refer to my notes to be specific.
Would it refresh your memory to refer to your report?
Yes.
Okay. Judge, can I have one moment, please?
Yes.
Detective, did you co-author an 8-page computer forensic report related to the items that were analyzed in this case?
Yes, I did.
Would that report refresh your memory?
Yes, it would.
Not sure if I asked, but may I approach, Judge?
Yes, you may.
Page number, okay. Oh, no, that's what you, that's fine.
So a couple things. I've handed you what's been, appear to be at least an 8-page document. Are you familiar with that document?
Yes, I am.
What is that?
This is our findings report.
What I'm going to ask you to do is to read through that, tell me when your memory is refreshed to the question as to how many thumb drives were ultimately analyzed, and then just go ahead and flip that over if you would, please. Does that refresh your memory, sir?
Yes, it does.
Go ahead.
3 thumb drives.
So you received 2 later from Jeff Holmes?
Yes.
What about that other one? When did you receive that?
That was at the initial scene.
Your Honor, may I approach the witness, please?
You may.
I've handed you what's been previously marked as People's Exhibit 4885 and 4886. Do you recognize those two?
Yes, I do.
What are those photographs of?
These are, the first one, 4885, is a picture of the CyberPower PC, the NZXT that we examined. And 4886 is a close-up of the evidence label that's on that computer.
The same computer?
Yes.
All right. Those photographs accurately depict the eCyber Power Tower, the NZXT, as you referred to. Those photographs accurately depict that tower when you conducted your examination upon it?
Yes.
Judge, I would move for admission of 4885 and 4886.
Is there any objection?
No objection.
Without objection, P-DR-4885 and 4886 are admitted and may be published.
Thank you. If we could have 4885, please. Thank you. The items that you previously described, the evidence items, the ones that you took into custody at the apartment, as well as the thumb drives that were later brought to you, did you conduct examination upon those items?
Yes, I did, along with Detective Leiker.
Okay. Now, I recognize there's a difference between the hard drive, like that tower, that type of examination, versus a cell phone examination. Is that fair to say?
Yes.
Did you conduct the appropriate examination on both of those items?
Yes.
Were the digital examinations, forensic examinations, conducted in accordance with the lab policies and protocols?
Yes.
Just so we're clear, where were the examinations, where did that take place?
At the Computer Forensics Lab at the Aurora Police Department?
You described earlier that you oftentimes work off of what a case agent had submitted to you as far as a request. In this case, did you get a request from a particular detective related to those items?
Yes.
Who was the detective that submitted a request?
Detective Apple?
Is that Detective Craig Apple?
Yes.
Gentleman to my right?
Yes.
What was the request from Detective Apple as far as the examination of those items? What was he requesting?
He was looking for images, documents, internet, web history, relating to anything involving firearms, ammunition, explosive, things like that.
Did you stay within the parameters of Detective Apple's request?
Yes.
Were you successful on conducting the examination of those previously mentioned electronic items?
Yes.
You described earlier about I think you said findings DVD, is that correct?
Yes.
What is a findings DVD?
Well, in this particular case, it was a Blu-ray because there was so much information, but a findings is whether it's a DVD or a Blu-ray, the disc that contains all the information that we located that was pertinent to the investigation. We call it bookmarking, and our forensics software creates this report for us with everything that we bookmarked, and it pulls the files that are associated with that into that disc so that we can present it to the case agent and they can use it.
How is that type of report different than, say, back when you were a detective in the non-computer area when you would write a report and put that information? How specifically is that findings Blu-ray in your case, how is that contained?
Well, we still do a written report that you would see like any other investigation and so forth, but this is all digital.
As far as the findings being digital, does that also include some of the images related to the items that you retrieved and looked at in your examination?
Yes.
In this particular case, did you create a findings DVD or Blu-ray, as you said, associated with the examination for those particular items?
Yes.
When you looked at the various items that you described, were there any of them that contained some of the information that was specifically requested by Detective Apple?
Yes.
What were the items that contained some of the information that was requested by Detective Apple?
There was documents, images, web history, and so forth.
Which particular devices contain those types of items?
I believe it was the NZXT tower computer, CyberPower, the iPhone, iPod. Mainly.
You talked about a Toshiba laptop.
Yes.
Did you conduct a forensic examination on that Toshiba laptop?
Yes.
Was there any items of evidence that were specifically related to Detective Apple's request or otherwise pertinent to his investigation?
None that we noted, no.
A LaPan tablet, I believe you stated that as well.
Yes.
What is a LaPan tablet?
It's a small tablet computer.
Did you conduct an examination of that tablet?
Yes.
Were there any items of evidence specifically related to Detective Apple's request?
None that we noted, no.
A total of 3 thumb drives, I believe you stated?
Yes.
Did you examine all 3 of those thumb drives?
Yes.
Was there anything pertinent on those thumb drives that were specifically related to Detective Apple's request?
No.
You described a modem, I believe. What exactly is a modem?
Modem is a device where you can hook it up to the internet and be able to access.
Was that modem even examined?
No.
Why not?
No reason to.
Did you also take into your custody some Netgear wireless adapters.
Yes.
What are those?
That's just so mainly you can use them on a laptop or something like that to connect to your modem to access the internet.
Were any of those items examined?
No,
And why not?
no need to.
So you still have before you People's Exhibit 538?
Yes.
That's the iPhone, I believe. Tell us, if you would, please, how did you conduct the examination of the defendant's iPhone?
We take the iPhone and we connect it to our Cellbrite equipment, which is basically an interface device that plugs into there, and it prevents any writing to that cell phone itself, and it copies the information off of that cell phone to our forensics computer and creates a file for us, and then we can process that file looking for contacts, addresses, SMS messages, which stands for short message service, text messages, internet, depending on the type of the phone, internet history, browsing, so forth.
When you're conducting an examination of an iPhone, is that a full forensic examination?
No, as I mentioned earlier, the problems with cell phones is the minute you turn that device on, it wants to start changing its memory, reorganizing it, make it more efficient and so forth. So each time you turn it on, it's going to change a little bit. It's not going to change the information that's on there unless a specific, and this is a reality nowadays, a specific command can be sent by a cellular service provider to wipe the information on that cell phone. So one of the other things that we'll do is we'll prevent any communications of that device to the cellular network to protect it.
Did you do that in this case?
Yes, we did.
Did it appear that this cell phone was wiped in any sort of fashion?
It did not.
Okay. Were you able to recover some of the contents of the iPhone using the software you described?
Yes.
Were you able to determine the owner name of that particular iPhone?
Yes.
What was that?
James?
Were you also, in conducting the examination of that iPhone, were you able to discern what the phone number is associated with that iPhone?
Yes.
Do you recall what that is?
Not specifically. I'd see the report.
Would it refresh your memory to look at your report?
Yes.
Okay, if I could just have you flip your report over with the court's permission, and again, let us know when that refreshes your memory.
Yes.
Direct your attention to the first page.
Okay.
And what was the phone number?
858-44-97348.
Can I have you flip your report back over for us, please? Do you recall what the network service was associated with that iPhone?
I believe it was Verizon.
Were you able to locate any specific email accounts associated with that iPhone?
Yes.
Describe that for us, please.
There was 2 email accounts, and I believe it was dsherlockb@gmail.com and dsherlockb@hotmail.com.
Were you able to look at images or photographs contained within that iPhone?
Yes.
How did you do that?
Once we acquire the image of it and create the file, and then the software processes that, and it categorizes those into different individual areas, like, say, the SMS messages, the text messages, the images. And then you can view those individually.
And did you do that in this case?
Yes, we did.
Were you able to save copies of those images?
Yes.
Are you familiar with the term metadata or metadata?
Yes.
What is that?
Metadata basically is data about data. So it's information that describes that type of file.
Were you able to recover any of the metadata associated with some of the images that you recovered from this iPhone?
Yes.
Were you able to save that as part of your findings Blu-ray?
Yes.
Also, the photographs, were those contained within your findings Blu-ray?
Correct.
Your Honor, may I approach the witness, please?
Yes.
I've handed you what's been previously marked as People's Exhibit 425. Do you recognize that exhibit?
Yes, I do.
What is that?
These are copies of the images that were on the cell phone, along with the associated metadata.
Did you personally recover those images related to your examination of this iPhone?
Yes, myself and Detective Leiker.
And are in fact those the images that you recovered?
Yes.
Is there also metadata associated with that exhibit as well?
Yes, there is.
Is that the metadata that you recovered from the cell phone that relates to those particular pictures?
Yes, it is.
Is there also amongst People's Exhibit 425 an image related to a web page?
Yes, there is.
And that was an image as well?
Yes, it is.
Okay. Also an image that you recovered from that iPhone?
Yes.
Do those photographs fairly and accurately depict the images that you recovered from the iPhone that's before you as People's Exhibit 538?
Yes, they do.
Judge, I would move for admission of People's Exhibit 425.
Is there any objection to the admission of P-TR-425?
No objection.
All right, without objection, P-TR-425 is admitted and may be published. Before you publish it, Mr. Edson, why don't we go ahead and take our lunch break? Unless you think you're going to finish within the next couple of minutes.
I'm not going to finish with the examination. I would request to publish at least one photograph.
Okay?
And then if we could please have and to be more clear, Judge, I'd request to publish one photograph and the metadata associated with that.
All right.
425-5, please. What are we looking at here?
Actually, let's take our lunch break, and then I'll talk to counsel for just a minute. All right, folks, this is a good time to take our lunch break. Please keep in mind all of my admonitions related to your conduct when you're not in the courtroom. I'll see you back here in an hour and a half, okay? So at approximately 1:30. Have a good lunch. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Mr. Essen, I just want to make sure that you don't run afoul of my order D-108. At pages 22 and 23, I stated that the testimony of Detective Madonna would be limited to describing the examination of the computers and electronic devices collected, including the methods and software employed, and that he would not render any opinions about what information was extracted, what the evidence means, or what the evidence is otherwise associated with. And what I meant by that is he can talk about the categories of information that he extracted from the computer, but my understanding is that the people did not intend to have him opine or testify about the specific contents of the images or whatever data may have been extracted from the computer, and to then testify related to what that information depicts or what that information means or what it's associated with or what significance it had in the investigation. Does that make sense?
It does. And perhaps the court should look at People's Exhibit 425, and I can explain to the court what my intention was and to make sure that it does not run afoul of the order.
Okay. What's your intention?
How this exhibit, and this would be similar to the iPhone, the iPod, as well as the tower computer, is a photograph of the image like the court just saw, the second page is the metadata associated with that. My question is limited to when that image was created. There's a created date on that, and that's essentially my questions. He's not going to be opining about how this photograph relates to the case, anything related to that. It's strictly, do you recognize this photograph? What date was it created? Photograph, what date it was created? That's my intention.
All right, I think that's within the bounds of the order. I think where you would run afoul of it is if you start talking about what's depicted in on this particular page. Oh, that's a picture of Mr. Holmes. That, I think, would be outside of the boundaries that I have set. So if he's going to say that's an image that was created on such and such a date based on the methods that I have described or the procedures that I have talked about, I think that's fair. But I think where he gets beyond his area of expertise is if he starts talking about what the contents of the images may be or the contents of the data may be and what significance they have in the case or what they are associated with or what they mean to him or what he thinks, what role he thinks they played in the investigation. Does that make
Understood,
sense?
Judge.
Okay, great. All right, is there anything else we need to talk about at this time?
Anything else, guys? Nothing for the people. Thank you.
Anything on behalf of the defense?
No.
All right, thank you. Enjoy your lunch break. I'll see you back here at about 1:30. The court will